Time for today's Legal Minute with the Law Office of Cooley, Shrair in Springfield. Today, we're joined by attorney David Shrair. We're talking about buyers' concerns when signing a residential purchase agreement. So what do buyers need to know before they sign on the dotted line?
Well, in Massachusetts, which has adopted the statute of frauds, there is a requirement that every contract for the sale of real estate be in writing and that all of the salient points be enumerated in the contract. If they're not, then either the buyer or the seller, as the case may be, will not be bound by those points which are not included therein.
And it goes without saying that it's imperative that you have a lawyer look over these documents. But what should you be concerned for? What specific line items and wording should you be looking for in these documents?
Well, the real issue is that most residential purchase agreements, certainly in Western Massachusetts, use the standard brokerage agreement prepared by the Real Estate Brokers Association. That's a basically good agreement, but there are issues that especially a buyer needs to be aware of. Number one, the purchase price and deposit have to be adequately and correctly stated. Number two, the mortgage contingency. If there's going to be a mortgage, then you must be sure that the buyer has adequate time to apply for the mortgage, have the mortgage lender respond back to the buyer so that they all fit within the time period set for the contingency. The inspection clause is also a similar clause which requires the buyer to have a home inspection if they're going to do so within a specified time period. The buyer has to be aware that it must be completed within that time period. The standard brokerage agreement contains a default clause that states that if the buyer defaults, then the deposit plus any other damages that the seller may seek will make the buyer liable for those damages. It has been our custom and most attorneys' custom to revise that clause extensively to provide that if the buyer defaults, the buyer's sole liability is the deposit, and there are no further damages either at law or in equity which the seller can exact. The last item is representations and warranties. If you've got a question as a buyer as to whether or not a roof is tight or there's never been water in the basement, then you really want to put it into the agreement. You want the seller to make that representation, and you want that representation to outlive the terms of the agreement.
And so often these terms and these contracts are trickier for people like me to understand, so that's why we employ people like you to help us through these times. Thank you so much for doing that today.
Thank you very much.
That's your Legal Minute, and for more information, just call 413-781-0750 or visit CooleyShrair.com.